We have a big show today, my friends. We are covering the now breaking Trump crime report. And the way today's show is going to be organized is as follows. First, we're going to talk about what's new in this report, right? Then, after we do that, we're going to still emphasize why this matters. And finally, after we get through that, we are going to talk about the what's next. And we'll throw in some Crazy Town, because Crazy Town is going to be, we're going to try to hit it. We're going to listen in on the Pete Hegseth nomination hearing before the Armed Services Committee. And you may think, doesn't that start at 9 a.m.? Things never start on time. But if it does, we will interrupt our regularly scheduled programming to hear that. Okay, guys, now, the best way, I think, to manage this is to share with you, to share the screen of what I have here for the report. And I want to make sure I've got that right in front of me right here. Now, I have shared, and I think I can throw it up again into the chat for you, the report. But the bottom line here in this breaking news is that Jack Smith, right? I'm going to tell you the bottom line, then I'm going to tell you what's new here and why it matters. The bottom line here is Jack Smith made it entirely clear that but for two things, he would have tried Donald Trump, and he had enough evidence to secure a conviction in the insurrection case. He has absolutely no qualms about making that statement. It is a fact. And what are those two things, according to Jack Smith? First is, he doesn't call it stupid, but the stupid Department of Justice policy, my friends, that says they will not try a sitting president. This is a policy of the Department of Justice. It is not a law. And at best, it should only apply, I believe, to indicting a sitting president. But this man was indicted when he was a citizen. But no one lifted that policy. And so as a result, that is one of the reasons. And the second reason, my friends, is because our fellow Americans decided to vote. They decided to vote for Donald Trump. He only won by a slim margin, and other people decided not to get out and vote. And then there were many people in swing states who were manipulated and foolish enough to cast protest votes for people like Jill Stein or to vote for Donald Trump, because they thought things would be better for people in Gaza and so on. But that's not going to happen. And they didn't believe that he was going to round people up and deport them. But that is going to happen. So we now have, thanks to everyone, thank you, America, the situation where Donald Trump was elected. And because of these two things, according to Jack Smith, that is why he did not bring the case. Now, I am trying to find my link to it, and I will get that right now so I can share it with you. So let me tell you, though, what is new about this report. And there's basically three things, my friends, that are new about this report. First, Jack Smith wrote a letter in his own name to Merrick Garland concerning this report. And that is new. And I think it's really important for us to actually look at that. And secondly, what is also new here are some footnotes and an appendix. And what is critical about these, to be clear here, is that, and I'm going to share this right now with you. What's critical here is that the letter that Jack Smith wrote addresses for history and for people today the bullshit that Donald Trump is trying to spin, that he was exonerated simply because the case was dropped. So that's one thing. Then there are some footnotes with the information in it. And I'm going to credit Lisa Rubin on MSNBC for pointing us in this direction. There's some footnotes in here that make it clear with new evidence that we haven't seen, like over 5 different interviews that the special counsel's team held, that Donald Trump actually and absolutely knew that he had lost the election to Joe Biden. And so even though in his public-facing remarks, he would repeatedly say, repeat the big lie and claim that he believed he won. Number one, there's substantial evidence that he absolutely knew he lost. Number two, there's substantial evidence that he had a plan to contest the election no matter what. And number three, there are family members who ratted him out, who said that he knew he lost the election, but it didn't matter because he was going to fight like hell. Win or lose, fight like hell. So also, more importantly, another point that we found out here, again, new information, is that Mike Pence didn't want to, we knew he didn't want to go along with this, but Donald Trump made a statement that even before Mike Pence said, no way, I'm not doing this, he claimed that he and Mike Pence were on the same page, were in agreement that they were going to contest the election in terms of the counting of the votes. And that was not true. Okay, folks, let's get to this. And I want to do a little bit of a dramatic reading here. And I am also keeping my eye on the chat in case folks have specific messages for us here to discuss. For me, there's no us, it's just me. It's me and Jack Smith. And you see I have the report here with Donald's face on it. Okay, so let's do that screen share and we can get, here we go. I think I've got this for you where you can see it. And I really wish, let me just see if I can download the original oh, there I did. What I really wish for you, I think I got this. I'm going to stop the screen share for 1 second, and I'm going to share something where you don't actually have those things on the sides. Let's do this. Okay, got it. Now we got a good screen share. Now, guys, I'm going to throw this in the chat, and I realize if you're watching this on replay, if it's right after it replays, it might not be up. The chat might not be up, so I'm going to throw it also in the comments if you are watching this. Now, here, if you go here, right where I am going to read from. I know it's small, but I put it in the chat. This is what we're looking at right now, is the letter. And here we go. I'll blow this up for a second. This is the letter. It says delivery by hand, the Honorable Merrick Garland, and this is about delivering the final report. And I am going to, I want to share that with you, but I also want to be able to let you know what it says. I'm going to read along with you right now. So you have it. I'm gonna stop the sharing, and you are going to follow along with me. Okay, here's how it goes. This was the letter that transmitted to Merrick Garland by Jack Smith. Okay, we are going to read this together. Here we go. And by the way, this was delivered by hand, which would be a way you would want to deliver this report, on January 7th. So that was 7 days ago. It was last Tuesday. Okay, here we go. Dear Mr. Attorney General, in the fall of 2022, former President Donald Trump was a subject of 2 separate criminal investigations by the Department of Justice. The first was an investigation into whether any person violated the law in connection with efforts to interfere with the lawful transfer of power following the 2020 presidential election. The second investigation focused on the possession of highly classified documents at Mr. Trump's Mar-a-Lago social club following his presidency. On November 15th, 2022, Mr. Trump declared his candidacy to unseat President Joseph R. Biden Jr., who had previously stated his intention to stand for re-election. Mr. Trump's announcement created a highly unusual situation. I'm having a hard time reading this letter because I'm just so upset that prior to that, Merrick Garland hadn't appointed a special counsel. But let me continue. Mr. Trump's announcement created a highly unusual situation in which the department, an agency within the executive branch, headed by Mr. Biden, was conducting criminal investigations regarding his newly declared challenger. Again, folks, if you're just tuning in, I am reading the transmittal letter. This is new that Jack Smith sent to Merrick Garland. Based on a long-standing recognition that, quote, in certain extraordinary cases, it is in the public interest to appoint a special prosecutor to independently manage an investigation and prosecution, end quote, you, as the Attorney General, promptly did so here to, quote, underscore the department's commitment to both independence and accountability in particularly sensitive matters, end quote. And here Jack Smith was quoting Garland's remarks on November 18th, 2022. I appreciate how polite Jack Smith is here. He said promptly. Promptly after the announcement, but fucking promptly would have been in March after he was sworn in, March of 2021. Let me show you. March of 2021 to November of 2022, April, May, June, July, August, September, October, November. That's 8 plus 12. That's actually 20 months. I say 18 months, but did I just do that math right? I think so. April, May, June, July, August, September, October, November. Yeah, plus a year, 20 months. I've been giving Garland credit. Okay. On the day, this is again Jack Smith continuing. On the day I was appointed, I pledged that I would exercise my independent judgment following the best traditions of Department of Justice and conduct my work expeditiously and thoroughly to reach whatever outcome the law dictated. With the aid of an outstanding team, that is what I did. Thank you, Jack. He goes on. Upon my appointment, I organized a staff of experienced career federal prosecutors, and together we conducted the investigations and subsequent prosecutions under our mandate consistent with the department's traditions of integrity and nonpartisanship that have guided all of us through our careers. Okay, I'm continuing now. I'm almost at the end of this letter. It's important to read. Okay, so then Jack Smith continues. Attorney General Edward H. Levy, who assumed the department's helm in the wake of Watergate, summed up those traditions best. And now here Jack Smith is quoting Levy. One paramount concern must always guide our way. This is the keeping of the faith in the essential decency and even-handedness in the law, a faith which is the strength of the law and must be continually renewed. Okay, blah, 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 blah. So then he cites history, and I'm going to keep scrolling through this. And he goes on and on, citing precedent. And then he talks about how he followed the principles of federal prosecution, which are the guidelines the Department of Justice follows when he was gathering evidence. And let me read this key passage now. Jack Smith said, while I rely greatly on the counsel, judgment, and advice of our team, I want to be clear that the ultimate decision to bring charges against Mr. Trump was mine. It is a decision I stand behind fully. To have done otherwise on the facts developed during our work would have been to shirk my duties as a prosecutor and a public servant. After nearly 30 years of public service, this is a choice I could not abide. And then he goes through the authority he has to submit the report. Now, he also, I love this, takes a dig at Donald Trump. Jack Smith says, the regulation, he also talks about how he was properly appointed. And he said, I was appointed the regulations under which I was appointed provided you with the authority to countermand my decisions, but you did not do so. Nor did you, the Deputy Attorney General, or members of your staff ever attempt to improperly influence my decision as to whether to bring charges against Mr. Trump. Okay, that's great, Jack Smith. And now this is my favorite part. And to all who know me well, the claim from Mr. Trump that my decisions as a prosecutor were influenced or directed by the Biden administration or other political actors is, in a word, laughable. Laughable. Okay, so at the end of the day, he also adds, this is toward the end of his letter, though not required prior to finalizing the report, my office provided an opportunity for counsel for Mr. Trump to review both volumes. I did not know that. Fine, they shared both volumes with Trump. Also, they shared them with the counsel for the co-defendants, his former co-defendants, in the classified documents case. That was Nauta and De Oliveira. And they were given only volume 2. And he says, after this review, counsel for Mr. Trump wrote a letter to you, and we have provided a written response. So that's another new thing to you, both of which you'll find as an addendum. And then he said, basically, and I am signing off. Okay, so that is new. That is Jack Smith's cover letter. What is also helpful, and this is where I'm going to now share my screen, because I really do want you to see how this report is organized. Okay, so let's share the screen. And you can see we are now looking right here at the signature by Jack Smith. Okay, what I want to share now, I'm scrolling down, that was page 4. What you can see here is what you're seeing right here, and let me just move this up, is the cover, right? This is the official cover of the report. It's called Final Report on the Special Counsel's Investigations and Prosecutions. It says Volume 1 of the election case. And this is a subtitle, Report on Efforts to Interfere with the Lawful Transfer of Power Following the 2020 Presidential Election or the Certification of the Electoral College Vote, held on January 6, 2021. And it makes clear the authority under which Jack Smith submits this and the date he submitted it. Now, I'm going to temporarily stop sharing with you so I can scroll without hurting your eyes to the table of contents. And now I will share again. What you can see here with this table of contents. This is a very helpful thing to look at. The table of contents here starts out with Volume 1. We can see that. And how is Volume 1 organized? First, it's the facts. So that lays out Section 1, the results of the investigation. And it details Donald Trump's pressure he put on state officials. Remember the conversation in Pennsylvania to just find those 11,700 votes, things like that. It also details the fraudulent elector plan, right? To have those fake electors try to present their votes to get counted. And it was his plan. The third thing in the investigation is his misuse of his official power through the Department of Justice. We also have the pressure he put on Vice President Mike Pence to break the law. And finally, details about what his supporters did, the attack on the Capitol. Okay? Now, the next thing here, which I want to share with you, and I'm going to pop in here. Again, I'm going to now, in case you are just joining us, I am going through the key highlights of the newly released Trump crime report about the both attack on the Capitol, his other interference in the election of 2020, right? This was released to the public just after midnight tonight. We're going to go through this, and then we are going to jump right in to live stream the Pete Hegseth hearing. But we're hitting the high notes here. But I want you to know how it's structured so that tomorrow morning, when I give you a deeper dive into this, you'll understand what we're doing. Now, the key thing here, I'm going to blow this up for you. We had just talked about the facts, right? The 5 factors that were revealed about Trump's interference in the election: pressure on state officials, his fraudulent election plan, his misuse of his power through the Justice Department, his pressure on Pence, and his supporters' attack on the Capitol. What about the actual law, right? Let's look at the law. And I'm blowing this up so you can see this more easily. The law, that is section 2, right? The law is section 2. And what the law says here, he's got A through F, right? That's actually 6 legal elements. The first 3 relate to the charges. The first charge brought against Donald Trump, it's called conspiracy to defraud the United States. That falls under 18 U.S.C. 371. This is the statute I teach in my white-collar crime class. To be clear, the word defraud here doesn't mean depriving of money or property. The concept of conspiracy to defraud the United States has been used historically and repeatedly, and is authorized by the Department of Justice to be used for any time someone would attempt to defeat a lawful function of government. And it has been used before when it comes to interfering in elections. So that was one thing he was charged with. The second thing Donald Trump was charged with was obstruction and conspiracy to obstruct. And that is under 18 U.S.C. 1512K, and that is conspiracy to obstruct an official proceeding. In this case, even though, so 18 U.S.C. 1512, technically the heading for that, if you want to get geeky, is tampering with a witness, victim, or informant. But subsection K says falls under whoever conspires to commit. Whoever conspires to commit any offense under this section shall be subject to the same penalties as those who were. I'm getting a little bit too much into the weeds, so I'm not gonna get into the weeds. But this is essentially conspiracy to obstruct, to interfere in this investigation under K and C2. So K is the conspiracy aspect, and C2, which is I want to read to you, C2, even though this is under tampering with a witness, victim, or informant, the obstruction section 1512 C2 actually says as follows. This applies to Donald Trump. Whoever corruptly, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so shall be fined under this title or imprisoned not more than 20 years or both. Now, he would not have gotten 20 years, but this would have been a hefty sentence. Okay, so we've got conspiracy to defraud the United States. We've got conspiracy, obstruction and conspiracy to obstruct. We also have the 18 U.S.C. 241, which was the conspiracy against rights. And this is one that has not just legal significance, but has also moral power, right? This conspiracy against rights speaks to us because it directly talks about interfering, injuring us, the people, with what he did. And just to read that to you, conspiracy against rights says if 2 or more persons conspires to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or the laws of the United States, or because of his having to exercise the same. In other words, Donald Trump was charged with and would have been convicted for a conspiracy to interfere with our right to vote under the Constitution and under federal statutes. So that's those three things. Now, he also lays out some defenses for which he thinks are not helpful to him. And then he details other charges that he decided not to bring because there was not, he felt, enough evidence. Finally, he talked about co-conspirator liability. Now we have another section that kind of goes through, the principles of federal prosecution, the analysis, also investigative challenges. This is new. Twitter, or X, was very uncooperative, is one thing that they add here. Donald Trump was uncooperative in asserting his executive privilege. Now, I am going to now stop for a second and stop sharing my screen because I've gone through the beginning of that. Tomorrow, I will pull out specifics that are new or shocking or, actually are important for us to repeat to people who are in denial. But what I want to do first is conclude for you, just tell you, because we're almost sort of at the end of this before I think Hedseth is going to be soon testifying. But I want to get for you to the very end of this, because I've shared with you guys on Blue Sky. And when I say the very end, I mean the end before we get to all the appendices, right? This is 174 pages. And but we also have a lot of appendices. So I'm going to just get you to page 137. And I'm going to share that screen with you right now so you can see that. Okay, here we go. This is the very end of this, and I'm going to blow it up for you. And let me scroll up a little bit. This is everything here, and I'm going to give you a little commentary. The department's view that the Constitution prohibits the continued indictment and prosecution of a president is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution, which the office stands fully behind. Indeed, but for Mr. Trump's election and imminent return to the presidency, the office assessed that the admissible evidence was sufficient to obtain and sustain a conviction at trial. Okay. So that seems pretty damning, but not just damning on Donald Trump, who would have likely been convicted, but it is also, without question, damning on the United States Supreme Court for dragging this out, and more importantly, the 18 or 20 months that it took for Merrick Garland to appoint a special counsel. And the idea that he is still trying to say that the only reason it was needed was because Donald Trump had officially announced that he was running for president is utter hogwash. It was already an extraordinary circumstance because, guys, Donald Trump was still out there as an election denier and continuing to undermine our vote by stirring up conspiracy theories. If And he was still someone who was critical of Joe Biden. It was still true from day one that Donald Trump was criticizing the Department of Justice. There is no question that the first person I blame is Merrick Garland. Great. He issues this report today. BFD. Better than nothing. That's not what BFD stands for, though. Right? And we are still waiting now because Eileen Cannon has put on hold Volume 2, which we really need to see about his misuse of classified information and the evidence that they had, what he was going to do with it. Was he going to sell it? Was he sharing it? Was he manipulating people? What the hell was he doing with that? And we deserve to know. And they should have dropped the appeal a while ago. So I don't know what's going on currently with that. Now, I want to check, and maybe one of my mods can check on C-SPAN to see if that hearing has begun. So we can look at that. I'm going to talk to you right now while I try to find C-SPAN live, and it should be, here we go. Let's see if I can pull this up. It seems to be a commercial for me. Susan's going to go check. So I feel like someone will tell me. I'm going to pull up C-SPAN when we can, because I think that would be really helpful for us. But I don't want to do it until it is going. Okay. So what do we know, the bottom line, and what are the implications? The implications is that Donald Trump was not exonerated. The bottom line is, but for Merrick Garland and the Supreme Court and the American voters, but mostly Merrick Garland and the Supreme Court, we are now in a situation where there is substantial evidence to secure a conviction against Donald Trump for conspiracy to defraud us of our rights to vote, conspiracy of rights, again, to deprive us of our rights to vote under the Constitution and state law, and also obstruction of the official proceeding of counting the vote and conspiracy to obstruct the official proceeding. All of that, but for Donald Trump being elected and for a policy at the Department of Justice not to continue cases against sitting presidents without any kind of tolling of statutes of limitations. That is the bottom line. Oh, the Hegseth hearing doesn't start until 9:30. Amazing. Because what that gives us an opportunity to do, if you would like to, is dig deeper into this report. Because the first couple of pages gives us an overview, and we can also take a look at, you know what, let's first look at the problems that Elon Musk caused for this investigation. Let's look into that. And then I'm going to show you the details at the beginning of the report as to why it made sense to charge Donald Trump, right? We'll have time to do that. So again, we're going to look at the problems Twitter caused. We're going to look at the sort of two-page kind of intro to this report. And then we're going to look at those footnotes about all the evidence that Donald Trump actually knew and was just BSing his supporters. He knew he had lost. Okay, so I'm going to, again, do my screen share with you. Here we go. And I have got the special counsel report right here for you. And remember, if you're just joining us, this is the beginning of the report. It's the transmittal letter, and we read some of that. And my favorite part of that transmittal letter is where he called the allegations that he was biased laughable. Here's that. And to all who know me well, the claim from Mr. Trump that my decisions as a prosecutor were influenced or directed by the Biden administration or other political actors is, in a word, laughable. Okay, So remember, I gave you the table of contents here. And what we have at the very beginning here and is that introduction. But what I wanted to find for you is Twitter. Okay, so oops, I can't do a search right now on here, but what I can do is let's do this out of order. Let's look at this intro and then let's go to the Twitter part of it. Okay, so this is, if you can see this is the intro here. This is the part, I'm only going to read key portions of this out loud because I don't be boring. This is the intro where he again talks about something he did in the transmittal letter, how it was in November of 2022 that Merrick Garland appointed him. And his mission was to investigate, or to oversee what was already an investigation into whether any person or entity violated the law in connection with efforts to interfere in the lawful transfer of power. Now, yes, there was already an ongoing investigation, but we all know from what we heard from inside the Justice Department and from the evidence that Merrick Garland was starting from the bottom and going up instead of doing what was so obviously in front of us that Donald Trump was the ringleader. Okay, fine. So he mentions the Supreme Court here. He said after the Supreme Court held last summer that Mr. Trump was immune from prosecution for certain misuse of official power alleged in the indictment, a second grand jury found probable cause to return a superseding indictment charging those same offenses based on non-immunized conduct. Okay, remember that happened? And again, same offenses: conspiracy to defraud the United States, obstruction of an official proceeding, and conspiracy to obstruct that official proceeding, and conspiracy against rights. Okay, so it says Mr. Trump was thereafter reelected as president of the United States, and as a result, on November 25th, 2024, the special counsel moved to dismiss the case against Mr. Trump because of the Department of Justice's longstanding position that the Constitution forbids the federal indictment and prosecution of a sitting president. Okay, then he talks about what is in this first volume. And then he talked about also, what I had already told you, that this is key facts that were gleaned. He said the factual section, the vast majority of that is already in public domain already. We know about it. I shouldn't say public domain, public record. Then he says the second section discusses the statutes that he's charged with violating, and applies the law to those statutes. And then talks about the charges that they didn't pursue. And then this third section explains why the decision to prosecute Trump was fully consistent with, and indeed was compelled by, the principles of federal prosecution. And then finally, describing, the investigative procedures again. And then finally, the fifth section discusses the issues, the problems that they confronted in investigating the case. And then we get this result, the result here. I'm just going to read to you a little bit here about the result, just a couple things, and then we're going to get to how Twitter was of no help. Okay, in 2020, then President Donald Trump ran for re-election. Ran for re-election against Joseph R. Biden Jr. Mr. Trump lost. As alleged in the original and superseding indictments, substantial evidence demonstrates that Mr. Trump then engaged in an unprecedented criminal effort to overturn the legitimate results of the election in order to retain power. Although he did so primarily in his private capacity as a candidate and with the assistance of multiple private co-conspirators, Mr. Trump also attempted to use the power and authority of the United States government in furtherance of his scheme. As set forth in the original and superseding indictments, when it became clear that Mr. Trump had lost the election and that the lawful means of challenging the election results had failed, he resorted, I got pushed to the next page, had failed, he resorted to a series of criminal efforts to retain power. This included attempts to use state officials to ignore true vote counts, to manufacture fraudulent slates of presidential electors in 7 states that he had lost, to force Justice Department officials and his own Vice President, Michael R. Pence, to act in contravention of their oaths and to instead advance Mr. Trump's personal interest, and on January 6, 2021, to direct an angry mob to the United States Capitol to obstruct the congressional certification of the presidential election and then leverage rioters' violence to further delay it. In service of those efforts, Mr. Trump worked with other people to achieve a common plan to overturn the election results and perpetuate himself in office. And then he goes through all the co-conspirators, all 6 of them. Tomorrow we can go and remind us of who those were. And the evidence shows that Mr. Trump used lies as a weapon to defeat a federal government function foundational to the United States democratic process. Mr. Trump's false claims included dozens of specific claims regarding certain states, such as that large numbers of dead, non-resident, non-citizens, or otherwise ineligible voters had cast ballots, or that voting machines had changed votes for Mr. Trump to vote against him. These claims were demonstrably and in many cases obviously false. Now, this is a key part. The office investigated whether Mr. Trump believed the claims he made. Evidence from a variety of sources established that Mr. Trump knew that there was no outcome determinative fraud in the 2020 election, that many of the specific claims he made were untrue, and that he had lost the election. He knew this because some of the highest ranking officials in his own administration, including the vice president, told him directly that there was no evidence to support his claim. This is key. Mr. Trump's private advisors, both within and outside of his campaign, told him the same. And it goes on and on and on from there. Now we're getting, now I want to get to the part, guys, about Twitter being very unhelpful. What I want to say, guys, is what I want to do is this morning, we're doing the Trump crime report. And so after I share the Twitter piece with you, right, I am going to open a new StreamYard to live stream the Hegseth hearing. We should have a different stream for that so people can find it later. It doesn't make sense to make it all the Trump crime report. But allow me now to share with you the part about what a pain in the ass Twitter was. Okay, so I am getting to that part, but I am scrolling without you having to get a headache. Okay, so okay, I'm going right back. I've got people being very unhelpful. I'm in that section. I think we all want to hear about the investigation here. And I thought I had found it. Let me just actually find in the index. I can find the table of contents. I can find the right page. That would be very, very helpful. The investigation challenges. Okay, that's on page 108, guys. So if you can turn to page 108, and we will all be literally on that same page. Here we go. I got it. I'm sharing. Okay. And share. Okay, you see this? We're all on the trouble with Twitter. Okay. Pre-indictment litigation with third parties. The Twitter/X search warrant. Mr. Trump's public statements, and specifically his posts on the social media application Twitter, constituted important potential evidence of his criminal conduct and intent. Accordingly, on January 17th, 2023, the office applied for and the district court authorized a search warrant requiring Twitter to provide certain information regarding Mr. Trump's Twitter account. At the same time, as is common in non-public criminal investigations to prevent individuals under investigation from destroying evidence or otherwise hampering the process, the office asked the district court to issue a non-disclosure order. Okay, this is key. A non-disclosure order, which would direct Twitter that it could not inform Mr. Trump that the office was seeking information regarding his account. And of course, the district court granted the request. Now, the search warrant required Twitter's compliance within 10 days of its issuance, but the day before that deadline, its senior director of legal informed the office, meaning the Department of Justice, it would not comply with the warrant by the next day. And maybe the office, in this case, I think the office at this point is the special counsel's office. Shortly thereafter, Twitter's senior director of legal further informed the office that it would not comply with the warrant without changes to the NDO, the non-disclosure order, permitting Twitter to notify Mr. Trump of the warrant. Twitter claimed the NDO impinged on its First Amendment interests in communicating with the former president, which according to Twitter were heightened because the warrant purportedly could implicate issues of executive privilege. That it conceded that it had no standing to raise any privilege issues. Now, I need to minimize this for a second and say something to you. Okay, guys? Oops. I am trying to do a better job of this. Just to be clear here, this is quite unusual. When companies get these orders, they typically comply with them. I've been an inside counsel, and we have had to give over customer information, which you would never do without a search warrant, right? You would never do that. And in this instance, it is outrageous that Twitter decided that it wanted to inform Trump in advance. Now, you might say to yourself, why do they even need a search warrant? Can't they just look at Trump's tweets? Well, as actual evidence in court, you can't just print out something on your screen, right? You have to prove that it was on his account and so on. So they actually need access to the account. Okay, let me continue with this, and then we will shortly get to the end. I mean, this is just outrageous. Okay, and great. Okay, so that happened. Now, this keeps going on and on. And at this, we get the, I'm sorry, here we go. This is, remember, they have no standing to raise these issues. And this is what is added. The district court later, this is the judge, described Twitter's actions as extraordinary and noted that its resistance to the non-disclosure order, that thing where they can't share with Trump that there's a search warrant, it appeared to be a first in the company's history. So Twitter always complies and never asks for changes, always gives over information, and always follows non-disclosure orders. So Donald Trump was the only special Twitter user. And it says, for what appears to be the first time in their nearly 17-year existence as a company, Twitter seeks to vacate or modify an order issued under the Stored Communications Act, commanding that the company not disclose the existence of the search warrant for a user's Twitter account, and further seeks to condition any compliance by the company with that search warrant on the user or user's representatives first being notified, etc. Okay, so then Jack Smith tries to deal with this in court, tries to bring Twitter in to show cause why they weren't in contempt of court. And this goes on and on and on. Thanks, Elon Musk. Now, when I say it is time to, we're going to pivot, and I am going to throw into the chat in 1 second a link so we can absolutely go live. So I am going to create a live stream as we're speaking right now, and I'll call it special. I just want to make sure you have this. And I'm going to schedule this for today at 9:30 a.m. and Hegseth hearing. And there will not be a thumbnail right now because I'm just creating that live stream for you. And give me 1 second. There's a process here, guys, because I don't want you to leave. I mean, I want to make sure that you get this link before you go. And I got it. I got it for you so that we can leave. Okay. Now I can keep talking. There is the link to the show that we are going to have momentarily in 5 minutes. So what I want to do, though, before we leave, is kind of do a little crazy town wrap up of this situation. Okay. And in order to do that, oh, sorry, before I do Crazy Town, I want to actually do something praiseworthy, which is as follows. We saw incredible, this is my person of the day. My person of the day right now, and it's not Jack Smith, even though he did a great job. My person of the day right now is Vladimir Zelensky, who we found out Vladimir Zelensky has volunteered to send Ukrainian planes to help us fight our fires in California, which is incredible. And I think that's amazing. Now, I want to now go to our little bit of Crazy Town music before I leave and meet you at 9:30 on the other stream. Okay, here we go. Crazy Town is that we are actually having a Senate confirmation hearing before the Armed Services Committee, where we all know that members of the committee, the Republican members included, most of them, the majority committee members, know this man is entirely unqualified for the job. He doesn't have the background in the Army. He doesn't have the background managing people. He doesn't have the temperament. He is a full-blown alcoholic, apparently, who has not thought of treatment or recovery. He has a history of documented sexual assault, if not rape. And if that's not more than this, his only career positions, for the most part, after leaving the military, were running nonprofit veterans organizations where he was accused of financial mismanagement. If you wanted to pick someone less qualified for this job, it would be hard to do so. And the fact that Donald Trump has made this a loyalty test and that we are going along with that is Crazy Town, my friends. And I'll see you at the live stream in a moment.